Sarah married her husband, a green card holder, 3 years ago. Her priority date has been sitting for over a year, stuck, going nowhere, the way these things usually do. Then last month, without warning, her category jumped forward 18 months in a single bulletin. She could finally file. She had a real shot. And then her attorney told her something that changed everything. The window to file under the current, easier rules closes in less than a month. If you're married to a green card holder, or you're the green card holder sponsoring your spouse, this is genuinely one of the most important windows to understand right now, because two things are happening at almost the exact same moment, and most people only know about one of them. Let's start with the good news because it's real, and it's significant. The State Department's August 2026 Visa Bulletin delivered one of the biggest single-month advances in years for the F2A category, that's spouses and unmarried children under 21 of lawful permanent residents. The final action date jumped from January 1, 2025, all the way to July 22, 2026, for almost every country, roughly 18 months of forward movement in one bulletin. For Mexico specifically, the date moved from January 1, 2024 to July 22, 2025. This is the kind of jump that doesn't happen often, and it means a huge number of couples who were stuck waiting are suddenly eligible to move forward with their green card case right now. Here's why that matters practically. The dates for filing chart for F2A has actually remained current worldwide throughout this, which means eligible applicants have been able to submit paperwork toward the National Visa Center or begin adjustment of status regardless of exactly where their priority date sits. That's rare. That's a genuine open door that a lot of families have been waiting years to walk through. But here's the catch, and it's the reason this video exists. This door isn't staying open indefinitely, and the thing closing it has nothing to do with visa numbers at all. Stick with me for a moment because understanding exactly how these two dates interact could be the difference between your case sailing through and getting caught in exactly the wrong window. On September 18, 2026, a new public charge policy takes effect. The Department of Homeland Security is rescinding the Biden-era 2022 framework and restoring much broader officer discretion to determine whether an applicant might become dependent on government assistance in the future. Immigration attorneys are being direct about what that means in practice. Greater scrutiny of applicants' financial circumstances, a wider range of factors an officer can weigh, and less predictability than the standard that's applied for the past 4 years. Quick pause here because if you or your spouse could be affected by either of these two changes, go ahead and hit subscribe and turn on notifications because we're going to keep tracking exactly how this transition plays out as September 18th approaches. Here's the part that makes the timing genuinely brutal for anyone caught in the middle. Alongside the new public charge rule, USCIS is also releasing a completely updated Form 1485. Older editions, even if they're e-filed or postmarked exactly on September 18th, will be rejected outright. Applications filed before that date remain governed by the current, more predictable public charge framework, even if USCIS doesn't actually decide the case until months later. So the operative question isn't just, am I eligible to file? It's, can I get a complete, correct application filed before this specific date? Because filing even 1 day late under the old form, or 1 day into the new rule, moves your entire case into a different, less predictable review standard. Think about what that actually means for a family in this exact situation right now. The F2A jump just opened the door. The public charge change is about to make walking through that door meaningfully harder to predict. And the calendar between those two events is measured in weeks, not months. So let's talk about who else this touches because F2A isn't the only category that moved. F1, F2B, F3, and F4 also advanced in the August bulletin, though nowhere near as dramatically as F2A. And there's a genuinely important distinction buried in all of this that a lot of applicants miss. Family-sponsored applicants get to use the more generous dates for filing chart, while employment-based applicants are still stuck using the stricter final action dates chart. Even if your priority date looks current under one chart, you cannot actually file unless USCIS has specifically authorized that chart for the month you're filing in. Checking which chart applies to your exact category every single month isn't optional. It's the difference between a valid filing and a rejected one. There's also a broader structural reason all of this is colliding right now. The government's fiscal year ends September 30th, and annual visa numbers reset October 1st. That means August and September are always tense months in the Visa Bulletin world. Some categories can retrogress, meaning their cutoff dates actually move backward, while others might become temporarily unavailable entirely as annual allocations run dry. Layering the public charge deadline directly on top of that fiscal year crunch is exactly why immigration attorneys are treating these next few weeks as unusually high stakes. So what should a family actually do sitting in this exact situation right now? The honest answer starts with treating September 18th as a real hard target, not a someday deadline. If your F2A priority date is current or getting close under the August Bulletin, that means moving on your filing this week, not next month. It also means double-checking the actual form edition you're using, because the I-485 itself is changing alongside the rule, and an outdated form can get rejected regardless of how strong your priority date is. If your case touches on finances in any way, past use of public benefits, a sponsor's income sitting right near the threshold, this is the moment to pull that documentation together, while the more predictable 2022 standard is still the one being applied. And if anything about your specific chart category or timeline feels unclear, a quick conversation with an immigration attorney this week is worth more than trying to piece it together from a bulletin and a Reddit thread, especially with this little runway left. Here's the honest bigger picture. A window like this doesn't come along often. 18 months of forward movement in a single bulletin is genuinely rare. But rare opportunities paired with a hard deadline are exactly the situations where families lose real ground, not because they weren't eligible, but because they didn't move fast enough while the more favorable rules were still in effect. Right now, today, the door is open. The question is whether it stays open long enough for the people who need it most to actually walk through. Before you go, make sure you've hit subscribe and turned on notifications because we're going to keep tracking exactly how this September 18th transition plays out and what happens to filings that land right on that line. If this video helped you understand a deadline that could genuinely affect your own case, share it with your spouse, your family, or anyone you know navigating this exact window right now. Thanks so much for watching. Stay informed, stay prepared, and take care.